Good afternoon, ladies and gentlemen. Welcome to the Geok Choo Distinguished Visitors Lecture. The Faculty of Law had established the Geok Choo Distinguished Visitors Program in 2012 as one of the several initiatives to pay tribute to the late Madam Geok Choo, the wife of Singapore's founding Prime Minister, the late Mr. Lee Kuan Yew, for those who are unaware. Today, I realize we have attendees from different parts of the world. I see on the list from UCL, from Australia, and also from SMU. So a big welcome to academics, legal practitioners, and to students. Under this program, the Geok Choo Distinguished Visitors Program, leading law academics around the world are invited to teach an intensive course at NUS for 3 weeks, and then to deliver a public lecture on a topical legal issue. The lecture will also be published in the Singapore Journal of Legal Studies. So there'll be no slides and no handouts today. You just need to wait to read the lecture with footnotes in the Singapore Journal of Legal Studies next year. Today, we are honored to welcome our 19th Geok Choo Distinguished Visitor, Professor Donal Nolan. Professor Nolan is Professor of Private Law at the University of Oxford and the Francis Reynolds and Clarendon Fellow and Tutor in Law at Worcester College, Oxford. He has taught tort, contract, international trade law, restitution, and commercial law, and has been a visiting professor at a number of universities, including University of Florida, Trento, and Sichuan University. He's a senior fellow of the University of Melbourne, a founding member of the World Tort Law Society, and an elected member of the American Law Institute. Professor Nolan's research is focused primarily on the law of tort, in particular on the law of negligence, the law of private nuisance, and the interface between tort law and public law. His illustrious list of publications, which number close to 100 books, articles, book chapters, and case notes, may be found on his profile page at the University of Oxford, and I certainly urge you to pick up a copy of Looney, Nolan, and Oliphant's tort law texts and materials after this lecture. Professor Nolan had just completed teaching the intensive course Advanced Torts at NUS Law this month. And I'm glad he still have the energy to deliver this lecture, and I'm delighted and honored to welcome him to deliver the 19th Geok Choo Distinguished Visitors Lecture today, titled Negligence and Autonomy. Over to you, Professor Nolan.
Thank you very much, David, for your kind words, and thank you also to the National University of Singapore for inviting me to give this lecture. It's a great honour and a privilege for me to be asked to deliver this lecture, and I'd like to express my gratitude to the National University of Singapore Faculty of Law for inviting me to perform this role and also for its hospitality and support over the course of the last month. It is, of course, a great shame that I'm unable to deliver the lecture in person, but we've all got used to this in the current circumstances, and I hope there will be a future opportunity to visit Singapore and to see people in person. So I'm going to talk today about the relationship between negligence and autonomy. It's a fashionable topic because autonomy is, as it were, all the rage, and it's a subject that has interested me for some time. Now, my discussion of negligence and autonomy is going to divide into 3 parts. In the first part, I'm going to make some general observations about the relationship between negligence law and autonomy. In the second part, I'm going to consider whether interference with autonomy should be recognised as a form of damage that grounds a negligence action. And in the third and final part, I'm going to consider the uneasy relationship between negligence doctrine and patient autonomy in the law relating to liability for medical non-disclosure. Now, I should make it clear at the beginning that although philosophers tend to distinguish between autonomy and freedom, lawyers, or at least negligence lawyers anyway, are not always so punctilious. And so in my lecture, I'm going to use the word autonomy in what I see as its broader legal sense, as encompassing not only the ability to make meaningful choices about the direction of one's life, in Joseph Raz's words, an ideal of self-creation, but also freedom of action more generally. For present purposes, I'm not persuaded that any further elucidation of the meaning of autonomy is required, but after hearing what I have to say, you may well take a different view. I should also add that my discussion pertains to negligence in Commonwealth legal systems generally, although inevitably my focus tends to be on my home jurisdiction, which is to say English law, or rather UK law, which in fact, of course, encompasses 3 different jurisdictions, albeit that the differences between them are not significant for present purposes. So I want to begin my consideration of the relationship between negligence and autonomy with 4 general observations about that relationship. The first observation is that since negligence law is, in Hanoch de Gan's terminology, a, quote, duty-imposing area of private law and not a, quote, power-conferring one, in my view, it's not plausible to construct an overall justification for negligence law in autonomy terms, as one can do, and as de Gan has done, when it comes to facilitative legal institutions such as property or contract. So I'm not expressing a view as to the validity of a theory of property or contract based on autonomy. I'm simply saying that you can see how you can develop such a theory. Seems to me to be impossible to do that in the case of negligence. The second observation I want to make is that although the law of negligence cannot itself be plausibly explained in autonomy terms, negligence protects autonomy as a second order value, because the kinds of injuries that ground negligence claims almost inevitably have a negative impact on the plaintiff's ability to live the life she would choose to live. Suppose, for example, that your negligence causes a car accident in which I lose a leg. The resulting disability significantly reduces the meaningful choices that are open to me in the remainder of my life. And hence, since my autonomy is in part a function of those choices, my self-determination. Many potentially significant options are now closed to me, potential careers perhaps, as well as leisure pursuits such as walking up mountains, while others are made much more difficult, so that my ability to incorporate those options into my life plan is now more challenging. And the extra time spent and cost incurred itself has autonomy implications. Furthermore, in the most serious of personal injury cases, the impact of the injuries on the plaintiff's ability to live the life she wishes can be nothing short of catastrophic. Indeed, very serious injury is even capable of depriving the plaintiff of the capacity to make life choices at all, and hence of the very possibility of living an autonomous existence. Now, this connection between autonomy and negligence may be obvious, but it's certainly not trivial. Many of the injuries that ground negligence actions are genuinely life-changing, and a large part of what makes them so is the impact of the resultant disability on the plaintiff's life choices. Although a poor substitute for the loss, the award of monetary compensation in such cases can finance practical measures that will help to restore some of the plaintiff's independence, and through awards for so-called loss of amenity, serve to acknowledge the effect of the injury on the plaintiff's ability to do those things she would otherwise have chosen to do. Furthermore, since loss of amenity damages are both tailored to the plaintiff's own particular interests and pastimes and assessed objectively, in the sense that they compensate for the actual deprivation rather than the plaintiff's subjective perception of it, we can see that negligence law recognizes and responds to the autonomy impact of personal injury on its, that is to say, autonomy's own terms. So negligence, if you like, takes autonomy seriously. My third general observation about the relationship between negligence and autonomy switches the focus from plaintiff to potential defendant. And here I am moving from a conception of autonomy as in philosophical terms to the more general question of freedom of action. Now, it's surely a truism that in setting the boundaries of negligence liability, the law must strike a balance between the security interests of potential plaintiffs and the freedom of action of potential defendants. And yet it seems to me that negligence lawyers, having been distracted by instrumentalist concerns, such as the largely spurious floodgates argument, have given insufficient recognition to the threat that negligence liability can pose to freedom of action. Now, two contexts in which that threat is particularly acute are emissions cases and pure economic loss cases. If we begin with emissions liability, and by that I mean liability for failing to confer a benefit on the plaintiff, it's generally accepted that duties of positive action pose greater threats to our autonomy than duties to act carefully. Because instead of the law saying, if you choose to do X, whether that be drive a car or perform brain surgery or whatever it is, you must do it with reasonable care, the law is now saying you must do X, rescue the drowning child, shout the warning to the blind person near the cliff edge or whatever, as opposed to Y or Z or whatever else it is that you might like to do at that moment. So the instruction that negligence law gives you in an emissions case is very different from the instruction that it gives you in other cases. And I hope it can readily be accepted, therefore, that a general legal obligation to exercise reasonable care to confer benefits on others would represent a grave threat to our autonomy, and that wide-ranging obligations of beneficence are better left to the moral and political realms. At the same time, however, we should be clear that this legitimate autonomy concern in respect of positive obligations has its limits. An obligation to pull the endangered child to safety or to shout to the blind person to be careful is likely to have only a very trivial impact on one's self-determination, so that opposition to a duty of easy rescue is difficult to sustain on autonomy grounds alone, although of course it may be justified in other ways, including perhaps the difficulty of drawing a sufficiently clear line between cases where the autonomy impact of the duty is trivial and those where it is not. This is maybe an example of a situation where the law responds to a legitimate concern with a bright line rule rather than trying to draw more subtle distinctions on the facts of individual cases. Now, the second context in which freedom of action concerns are central to negligence law's abstentionist stance is recovery for pure economic loss, by which I mean financial loss that does not result from damage to the plaintiff's person or property. A general right not to suffer negligently inflicted economic loss would again represent a very significant threat to the autonomy of potential defendants, because the range of actions which may foreseeably cause economic loss to other people is so much greater than the range of actions which may foreseeably cause them personal injury or property damage. Examples of such actions include opening up a supermarket down the road from a grocery store, thereby reducing its custom, a financial commentator criticizing a company with the result that its share price falls and its shareholders lose money, even a footballer scoring a goal in a match so that a gambler loses a bet, and so on and so forth. These are all the things that we all do every day which have financial implications for other people. Now, subjecting all of these actions to a standard of reasonableness is pretty much inconceivable. Though again, as with emissions, the force of this autonomy concern can be substantially lessened, provided a duty of care in respect to the economic interests of others is sufficiently narrowly tailored. But a general right, a general obligation to take reasonable steps to protect the economic interests of others seems to me to be completely impractical. Now, if autonomy considerations serve as a partial justification for the general no recovery rules in respect of emissions and pure economic loss, which are observable in common law systems, they may also help to explain the most important exception to those no recovery rules in English law, which is the doctrine of assumption of responsibility. In a recent article on assumption of responsibility, I defined it as the taking on of a task for another person in circumstances in which it's plausible to imply an undertaking to exercise due care in the performance of the task. So that is what assumption of responsibility means to me. Taking on a task for someone in circumstances where it's plausible to imply an undertaking to exercise due care in the performance of the task. And also argued in that article that one of the reasons that it may be justifiable to tie obligations of due care to prior assumptions of responsibility is that in such cases, any autonomy concern is alleviated by the fact that, first of all, the defendant has chosen to take on a relevant responsibility in respect of an aspect of the plaintiff's well-being, and secondly, that the law allows the defendant to make clear that no liability is to attach to such an assumption of responsibility, and also to limit its scope in a number of important respects. So if we see the sort of one of the central concerns around liability for omissions and economic loss as being autonomy or freedom of action of defendants, potential defendants, it seems to me to make perfect sense that a prior assumption of responsibility should be a situation in which we are prepared to impose liability. My fourth and final general observation about the relationship between autonomy and negligence is that we should be careful not to overplay the significance of autonomy considerations in negligence law, and instead to recognise the limit of autonomy's justificatory power. And I want to give two examples to bear out this point. So the first example is a case called Greater X and Greater X, which is a first instance decision in the English case law on liability for psychiatric injury suffered by so-called secondary victims, which is to say persons who have suffered mental trauma as a result of witnessing the death, injury, or imperilment of another. And I'm going to refer to that other as the immediate victim. So the defendant in the Greater X case have been badly injured in a road accident caused by his own careless driving. And it just so happened by coincidence that his father was one of the fire officers who attended the scene and who helped to extricate his son from the car in which he was trapped. As a result of this experience, the father developed post-traumatic stress disorder, and he brought a negligence action against his own son in respect of this psychiatric illness. Now, although the father satisfied the requirements for secondary victim recovery that were laid down in the authorities, so there were various restrictions, or are various restrictions on secondary victim recovery for psychiatric injury, the father satisfied those. But Justice Cazalet held that as a matter of law, an immediate victim owed no duty of care to a secondary victim traumatized by an injury that the immediate victim had negligently or deliberately inflicted on herself. And one reason that the judge gave for this rule was that the imposition of a duty of care in these circumstances would be a significant limitation upon an individual's freedom of action. If, for example, she could be liable for the trauma which her suicide would cause others. Now, with respect, this seems to me to be a completely unconvincing invocation of considerations relating to autonomy or freedom of action. Surely the last thing on the mind of a person bent on self-harm or suicide is the possible liability of themselves or their estate to someone traumatized by their actions. And in the highly unlikely event that such a person is both aware of and concerned about such a possibility, the impact on their autonomy is in any case generally going to be negligible, since they need only take reasonable steps to ensure that no one close to them witnesses their potentially trauma-inducing actions. So I see Greater X and Greater X as an example of a case where considerations relating to self-determination or autonomy are used when really there is very little force in that argument. There are also other problems with the rule set out in Greater X, but I won't go into those because they're not relevant to this subject. Now, like the judge in Greater X, some academic commentators are also prone to exaggerate the force of autonomy considerations in the negligence context. And a good example here is the argument made by a number of scholars that in a medical malpractice case where the defendant's negligence has deprived the plaintiff of a less than 50% chance of a successful clinical outcome, an award of damages can be justified on autonomy grounds, since a result of the negligent treatment was that the plaintiff lost the option of receiving non-negligent treatment. So what this argument does is it frames the claim for loss of a chance in a medical negligence context in autonomy terms by saying the plaintiff has lost the choice of receiving non-negligent treatment. Now, I have to say that I find this argument completely unpersuasive for at least 3 reasons. The first reason is that the plaintiff never did lose that option at all, as she was always free to seek a second opinion. The second reason is that it would follow from the acceptance of this argument that an award should be made in a loss of a chance case to a patient with the capacity to make choices, but not to one who lacks that capacity, whether through age or otherwise. And that is an outcome that I, for one, find unpalatable. And the third and perhaps most important reason is that the argument seems to me to completely miss the point. If somebody hits me over the head with a brick so that blood is pouring down my face from the gash in my scalp, it would seem very odd to characterize my complaint against them as the loss of the option of not being hit over the head with a brick. Similarly, in the loss of a chance case, it seems to me to be highly artificial to characterize the wrong as the loss of the option of being treated non-negligently. Unlike in, say, a medical non-disclosure case, which I'll turn to shortly, here the essence of the patient's complaint relates to the negligent treatment and its possible consequences for the patient's health, not to the inability of the patient to exercise an informed choice. In my view, the fact that any loss of choice in this scenario lacks significance, independent of the reduction in the chance of a positive outcome with which it is associated, shows that analysis of the patient's complaint in autonomy terms is quite simply misguided. So I don't think considerations of autonomy can help us to solve the problem of loss of a chance in medical negligence. So that concludes the first part of the lecture. I'm going to move on to consider 2 more specific aspects of the relationship between negligence and autonomy, beginning with the question of autonomy interference as damage in a negligence case. So again, I want to make some preliminary points about this question. The first is that my concern here is with loss of autonomy as damage. In other words, the kind of interference with a person's interests that grounds a cause of action in negligence, rather than with the distinct question of whether a plaintiff who has established such a cause of action should be entitled to recover for loss of autonomy as a head of damages. So my concern is with whether loss of autonomy can actually be the basis for bringing a negligence claim, rather than whether you can recover for loss of autonomy when you have a negligence claim. Having said that, some of the considerations that in my view are relevant to this question of damage, may also be relevant to the question of damages. So there may be some connections between the 2 questions. The second preliminary point I want to make is that it's important not to confuse the question of autonomy interference as damage with the very different question of whether in medical non-disclosure cases, the court should respond to autonomy considerations by adapting the negligence rules concerning matters such as breach of duty and causation. So the subject matter of cases such as Montgomery and Lanarkshire Health Board and Chester and F. It's not that question. But again, a caveat is needed because in Chester and F. Lord Hoffman suggested that perhaps the solution to the issue in that case lay in what he called a small solatium to mark the infringement of the patient's autonomy. And that shows us that there's a link between cases like Chester and the question of autonomy interference as damage, as it can be argued that instead of altering the causation rules in such cases in order indirectly to vindicate a patient's autonomy interest by allowing recovery for physical injury arising out of the medical procedure, it will be better to vindicate that interest directly by awarding compensation for the autonomy interference itself. In other words, an argument against modifying the rules on causation in these cases is that actually we should do this more directly, protect the patient's autonomy interest more directly by compensating their loss of autonomy. The final preliminary point I want to make about autonomy interference as damage is that when considering this question, it's helpful to distinguish between interference with autonomy per se and specific forms of autonomy loss, such as interference with reproductive autonomy and restrictions on freedom of movement. In an article I wrote on new forms of damage in negligence back in 2007, I argued that while the latter might usefully be considered to amount to damage, the former should not, and that remains my position. So my basic kind of message on the question of autonomy interference as damage is that we shouldn't recognise loss of autonomy per se as damage, but that we should be prepared to recognise specific forms of autonomy interference as damage in negligence. Now, before I go on to explain why that's my view, it will be helpful to put the discussion in context by briefly considering three cases in which plaintiffs sought compensation for loss of autonomy. And the first of these cases is the decision of the Israeli Supreme Court in Dhaka and Cartmel Hospital. The plaintiff in this case was admitted to the defendant hospital for an operation on her left leg. While she was on the operating table and had already received sedatives in advance of undergoing anaesthesia, she was asked to sign a consent form in respect of a biopsy operation on her right shoulder, which she did. The biopsy was then carried out and it revealed no malignancy, but the shoulder on which the biopsy had been performed suffered some damage, and the plaintiff sought compensation from the defendant in respect of that injury to her shoulder. Israeli Supreme Court held that the defendant had been negligent in not obtaining the plaintiff's informed consent for the biopsy, but that she could not recover for the physical injury that had resulted from the procedure because she would almost certainly have agreed to it even if she'd been fully informed of the risks. So that aspect of the case is relatively straightforward. She's suing for the physical injury on grounds of non-disclosure, and the court is saying there was a breach in respect of non-disclosure, but it didn't cause the injury because she would have had the biopsy anyway. However, a majority of the court held that the plaintiff was entitled to recover compensation for the violation of her autonomy in not obtaining her informed consent, and that this was a separate head of damages in tort claims in Israel. The compensation awarded under this head was the equivalent of about 5,000 Singapore dollars. So a fairly modest sum of compensation awarded by the Israeli Supreme Court for loss of autonomy. Now, the decision in Dhaka is at odds with the reasoning of the Singapore Court of Appeal in ACB and Thomson Medical, a reproductive negligence case involving a mix-up in an IVF clinic, where it was held by the Singapore Court of Appeal that loss of autonomy should not be recognised as an actionable injury in its own right. And Dhaka is also inconsistent with the English case of Shaw and Kovac, where the claimant was the personal representative of a man who had died following a medical procedure which had been carried out by the defendant doctor. Now, it was conceded by the defendant in Shaw that the deceased had not been properly informed of the risks of the procedure, and that if he had been, he would not have undergone the operation. But although an award of just over £15,000 was made for pain, suffering, and loss of amenity in this case, the English Court of Appeal rejected a separate claim for damages for, quote, loss of personal autonomy, which it considered was contrary to legal authority and principle. And it also refused to recognise a new cause of action for the wrongful invasion of personal autonomy. So the argument was framed in two ways in Shaw. One, that a new head of damages for loss of personal autonomy should be recognised. And secondly, that the court should actually recognise a new cause of action in respect of loss of autonomy. And both of those arguments were rejected by the Court of Appeal. It's interesting just to note that Shaw and Kovac is a case where there is a cause of action arising out of the non-disclosure, but because the patient had died, the quantum of the award that was made to the estate was relatively low, and there was a suggestion in ensure that the plaintiff was really bringing the loss of autonomy claim as a way of compensating the estate for the loss of life expectancy, which of course is not actionable in as a head of damages in English law. Now, I just wanted to set those cases out to give a sense of what's at stake here, if you like. I want now to proceed to discuss various objections that have been made in the case law and literature to this idea of loss of autonomy as damage. But before I do so, I want to acknowledge my debt to Craig Pershouse of the University of Liverpool, whose pioneering work on autonomy and damage I have found very useful in preparing this lecture, and also to Justice Andrew Fang of the Singapore Court of Appeal for his really comprehensive exploration of this question in the ACB case. So one of the objections that was made to recognition of loss of autonomy as damage in the ACB case is that damage entails the plaintiff being left worse off by the defendant's conduct, and that sometimes depriving a person of an aspect of their personal autonomy can leave them better off rather than worse off, as where, for example, a gambling addict is barred from using gambling websites. So this is one objection that was made. But I have to say that with respect, I find this argument unpersuasive for the simple reason that, in my opinion, it's a mistake to equate damage with being left worse off. After all, established forms of damage, such as physical injury, can also, in fact, leave the plaintiff better off. Suppose, for example, that the fact that the defendant negligently broke your leg prevents you from taking a flight which crashes on takeoff, killing all on board. So, as I argued in a 2017 article entitled Rights, Damage and Loss, definitions of damage in terms of detriment or being worse off, in my opinion, confuse the concept of damage with the very different concept of loss. So, because of my views on damage, I don't share that first objection that was made in ACB to autonomy loss as damage. A more convincing argument against recognition of autonomy loss as damage is in my opinion, is the difficulty of pinning down the autonomy concept itself. And this is what Justice Andrew Fang called the conceptual objection in ACB. Now let's consider just a handful of the many difficulties. One is around defining autonomy. So one is that while some philosophers argue that our autonomy interests are limited to the making of valuable choices, others take a different view. Another problem is that according to some conceptions of autonomy, it's not a feature of persons at all, but rather pertains to the will or to certain actions. So there's no such thing as an autonomous person, there's only an autonomous action. And a third, more specific difficulty in the medical non-disclosure context is that it has been argued that no relevant account of autonomy generates an obligation on a health professional to disclose the risks and benefits of a proposed treatment, and that respect for patient autonomy requires only that the patient understand in general terms what the procedure involves and is not manipulated into consenting to it. And this is sort of ties in with something that I think is important to emphasize about autonomy and medical non-disclosure, which is that it's actually by no means obvious why a health professional is under an obligation based on autonomy considerations, not only to tell the patient in general terms what's going to happen to them and not to in any way try and manipulate their decision making, but also to actually positively inform them of things which, in theory, the patient could find out about from other sources. Now, I'm not endorsing that view that autonomy considerations are not in play in those situations. I'm simply using it as an example of the lack of clarity and lack of consensus around what exactly autonomy entails. Now, all these doubts and uncertainties about the concept of autonomy can be contrasted with the position regarding established forms of damage, such as physical damage to personal property, where there's broad agreement as to what these things mean, even if there are, of course, difficult cases at the margins. So we all, I think, share a sort of broad sense of what it means to talk about physical damage to property. My point is, I don't think we share that consensus around what autonomy actually means. And the fact that there are very different philosophical conceptions of autonomy and the lack of agreement as to the meaning and significance of the concept is a powerful and, in my view, decisive argument against elevating it to the status of a protected interest in tort law. So in my view, this alone is a good enough argument to reject the idea. And I think the force of this objection is illustrated by the dark art case, the Israeli case, where it seems to me from reading the judgment that the judges in the majority were not really sure what it was that they were compensating the plaintiff for. But in addition to that really powerful objection, there are a number of other objections to autonomy interference as damage, which I think have some force, even if they are perhaps not decisive in their own right. One of these is the difficulty of disentangling loss of autonomy from existing forms of damage, such as personal injury and property damage. Now, as we've seen, the suffering of these paradigmatic forms of damage generally entails a loss of autonomy. And the damages awarded for personal injury, in particular, are designed in part to compensate for that loss, while the damages awarded in property damage cases enable the plaintiff to repair or replace the property and hence to limit any autonomy loss that the damage brings about. It's not entirely clear, therefore, how a freestanding claim for loss of autonomy could comfortably coexist with orthodox negligence actions such as these, since either the defendant will be exposed to double recovery or a difficult separation out of the autonomy interference from the remainder of the patrimonial loss would be required. By contrast, no such complications arise in connection with the existing heads of damage recognised in negligence law, such as personal injury and property damage themselves, because these are mutually exclusive concepts. Possible response to this overlap objection is that loss of autonomy should be recognised as damage only in circumstances where there's no claim for personal injury, as, for example, in the Israeli case. But that still leaves the problem identified by Pershouse that allowing recovery for loss of autonomy could undermine restrictions on recovery and negligence for setbacks such as the suffering of pure economic loss or psychiatric illness, which can, of course, also have implications for a person's autonomy. So this seems to me to be an additional objection, possibly not decisive, but something that will complicate the law if we allowed freestanding claims for loss of autonomy. How would we separate those out from other actions that we allow in negligence for personal injury? And how would we prevent it from undermining rules of negligence law relating to economic loss and psychiatric illness? Now, a further objection that can be made against recognition of loss of autonomy as damage in its own right is that it's difficult to put a monetary figure on the loss. This objection is linked to the more fundamental objection that the concept of autonomy is nebulous, because one consequence of that is that if it's decided that compensation should be paid for loss of autonomy, then it's not entirely clear what the compensation is for and what considerations should be determinative of the size of the award. And these difficulties are, in my view, also apparent in the medical non-disclosure context. Should, for example, an award for loss of autonomy be made in that context, even if the procedure for which informed consent was not obtained was successful? And what if it's clear that the patient did not want to exercise a choice, but preferred to leave it to the doctor to decide? Should such a patient also be entitled to an award for loss of autonomy? Furthermore, to what extent, if at all, should the quantum of the award depend on, first of all, the significance of the procedure, including the gravity of the risks involved. Secondly, whether the information was withheld from the patient deliberately or inadvertently. And thirdly, whether the plaintiff would have agreed to the procedure if properly advised as to the risks. There are no easy answers, I think, to any of those questions, and they illustrate the difficulties of deciding how much compensation to give for loss of autonomy and what considerations should be relevant to the assessment of damages. A final objection to recognition of loss of autonomy as damage is that it may be unduly burdensome for potential defendants, since there are such a wide range of actions which may affect another person's autonomy in potentially significant ways. Things like, for example, not giving that person a job. This problem is again exacerbated by the difficulty of pinning the concept down, as it may be hard to know in advance what the law will consider to be an actionable interference with autonomy, which makes it more difficult for potential defendants to know what it is that they're required to do in order to avoid incurring negligence liability. It's possible that this final concern could be allayed to some extent by imposing limits on liability for loss of autonomy at the duty of care stage. So we're only talking here about whether we should recognise loss of autonomy as damage, and we can still control the extent of that liability through the duty of care mechanism. But nevertheless, it seems to me to be another powerful argument against recognition of loss of autonomy as such as damage. So for all these reasons, particularly the first, particularly the difficulty of pinning the concept down, it would, in my view, be a mistake for negligence law to recognise loss of autonomy per se as damage. However, I have no objection to the recognition of specific forms of autonomy interference as grounding claims in negligence. And indeed, I think that this is a potentially desirable move for the law to make. In these sorts of cases, the specific nature of the autonomy loss that the plaintiff has suffered serves to allay, at least to some extent, the concerns raised by recognition of interference with autonomy as a form of damage at a more general level. So I think by honing in on specific forms of autonomy interference, we can surmount some of those objections to recognition of autonomy loss per se as damage. Now, one example of a specific form of loss of autonomy that may merit protection by the law of negligence is interference with freedom of movement. In common law systems, the interest in freedom of movement is preeminently protected by the tort of false imprisonment. But I think the better view is that, like other forms of trespass to the person, that tort is now limited to cases of intentional interference. And yet our interest in freedom of movement is surely significant enough to merit protection against inadvertent interference, in which case recognition of loss of this liberty as a separate head of damage in negligence is necessary and appropriate. In, for example, a case where an asylum seeker is detained for a period of months as a result of an administrative error on the part of the immigration authorities. So it is, I've written on this previously, but it's not absolutely clear that freedom of movement itself is a protected interest in negligence, although there are some UK cases which suggest that it is, and I'm arguing that that should be the case. Another example of a specific type of autonomy interference that should and increasingly does amount to a form of damage for negligence purposes is loss of reproductive autonomy. As the American scholar Dov Fox has pointed out, determinations about having children are amongst our most important life decisions. And, quote, the wrongful frustration of reproductive plans disrupts personal and professional lives in predictable and dramatic ways. In this instance, as with negligent imprisonment, it's possible to hone in on a particular form of autonomy loss and then to differentiate it, at least to some extent, from other harms that may arise out of the same act of negligence, such as an unwanted pregnancy, for example, or the financial cost of bringing up a child conceived as a result of a failed contraceptive procedure. Now, in the case of reproductive negligence, at least two specific advantages of recognition of loss of autonomy as damage can be identified. One is that the possibility of treating the loss of autonomy as a form of damage may enable the courts to recognize the existence of a wrong and to give substantial compensation for it, while at the same time moving the focus away from the, quote, burden of bringing up a particular child, with all the negative connotations that that has for the child's dignity, and refusing to shift the economic component of that burden from the parents to a healthcare provider. So the award of a conventional fixed sum to both parents to mark the substantial impact on their life choices of the healthcare provider's negligence may therefore be thought to represent a reasonably balanced solution to the difficult issues raised by such cases. It does compensate them for their loss of autonomy, but it doesn't, we don't get involved in compensation of the cost of upkeep, and we don't conceive of the damage in terms of the burden of the unwanted child. And that is in fact the solution that the UK courts arrived at in those cases, to give a fixed sum of £15,000 compensation to the parents for their loss of autonomy. The second advantage of recognition of lost autonomy as damage in this context of reproductive negligence is that it more accurately reflects the essential nature of the plaintiff's complaint than alternative characterizations of the plaintiff's injury. So, for example, in cases where the defendant has negligently damaged or destroyed sperm that represented the plaintiff's only hope of biological fatherhood, focusing the award of damages squarely on the loss of reproductive choice brought about by the negligence seems much preferable to artificially stretching existing forms of damage, such as personal injury and property damage, to encompass what's occurred. And it provides a more transparent basis on which to assess damages that compensate for the gist of the injury done. So when one looks at these cases, there are cases here and elsewhere on destruction of sperm and so on. The courts consider, is it property damage, is it personal injury? These seem to me to be inappropriate characterizations of the gist of the wrong, which is the removal of the ability to be a father. And I think the law should respond to that appropriately by actually awarding compensation for that loss, rather than trying to push this into another category. Sticking with reproductive negligence, a similar point, I think, is that as Margaret Fordham has pointed out, it may be preferable for the law of negligence to treat an unwanted pregnancy as a form of sui generis autonomy harm, rather than to treat it as a personal injury, which is the characterization that most Commonwealth courts have arrived at. A characterization which I think is problematic for various reasons. But one thing we do need to remember here is that the classification of the damage may be significant for other purposes, such as limitation of actions, where the rules distinguish between personal injury and other forms of harm. So we need to be mindful of that when we're deciding how to characterize these harms. If we say it's not personal injury, that may have limitation implications, for example. Okay, so that takes me to the final part of my lecture, the final aspect of the relationship between negligence and autonomy that I wish to consider, which is the law of medical non-disclosure. Now, the modern view of this area of law firmly grounds the obligation to disclose medical risks in concerns over patient autonomy. And indeed, it's the law on this subject that provides us with the most obvious intersection between negligence and autonomy. However, it's increasingly obvious to me that this issue cannot comfortably be located within the framework of negligence law, and indeed a yet stronger claim is possible, namely that in, many Commonwealth jurisdictions, liability for medical non-disclosure is no longer negligence liability at all. Now, before I turn to that stronger claim, I want to highlight, first of all, just how uneasy the fit is in common law systems between the law on medical non-disclosure and the broader framework of the negligence tort. The first thing to note here is that while in every other negligence case, the fault of the defendant consists of exposing the plaintiff to unreasonable risks of injury or other harm in totality, in medical non-disclosure cases, the patient's essential complaint is rather that the doctor's conduct was negligent because it deprived the patient of the opportunity to make an informed choice as to whether or not to run a particular risk. So in other words, we can say in all other negligence cases that the negligence consists of exposing the plaintiff to unreasonable risks of harm or injury. We cannot say that in medical non-disclosure cases. This is shown by the fact that even if the totality of the risks associated with not having the operational procedure in question quite clearly outweigh the totality of the risks of having it, the doctor may still be negligent in not disclosing one or more of those latter risks. So you can immediately see that something is different in these cases. Another aspect of the law of medical non-disclosure that demonstrates the lack of fit with general negligence doctrine are the departures from orthodox causation principles that have been felt necessary in this particular type of case. Now, beginning with factual causation, we immediately get the problem that the patient in these cases generally needs to establish that if properly informed of the risks, she would not have gone ahead with the procedure in question. And that means, first of all, that she has an incentive to give self-serving testimony. And secondly, that even if she's honest, her testimony as to what she would have done may, in hindsight, be affected by the fact that the risk in question materialized and caused her injury. So if you put yourselves in the shoes of a plaintiff in a medical non-disclosure case, for obvious reasons, they need to say that they wouldn't have had the operation if the risk had been disclosed, and that assessment may be affected by hindsight. And this is an obvious problem. Now, the way that courts and legislatures have responded to those concerns have varied, but in some cases, that response has been to depart from general negligence principles, as in the Supreme Court of Canada's decision in Ribble and Hughes, that in these cases, recovery should require proof that a reasonable person in the patient's position would have chosen not to undertake the procedure if warned. In other words, the Supreme Court of Canada shifts the focus from this patient and what this patient would have done to what a reasonable patient would have done. But this approach to a question of factual causation, which is by no means unique, it was also adopted by the US Court of Appeals in a famous American informed consent case, Canterbury and Spence, is completely unique as far as negligence law is concerned. And it alters the nature of the causation inquiry in a quite fundamental way. Because causation is simply about, or factual causation is what would have happened if the breach had not occurred. And obviously that requires us to look at the position of this particular patient and what they would have done. And this shift to what a reasonable patient would have done is therefore a fundamental challenge to basic principles of factual causation. Now, difficult questions can also arise in medical non-disclosure cases when it comes to remoteness of damage or scope of liability. The leading UK decision in this area is the controversial case of Chester and Afshar, where a majority of the House of Lords departed from orthodox remoteness principles to enable a patient to recover for injury that was factually caused by a negligent failure to warn, even though she admitted that if she had have been warned, she would eventually have submitted to the procedure in any case and thereby been exposed to the risk in question. Now, in Chester, the majority expressly justified this departure from causal orthodoxy by reference to autonomy considerations, arguing unpersuasively, in my opinion, that if liability were not imposed in this type of case, the doctor's duty to warn would be largely emptied of content, with the result that the law would fail adequately to protect patient autonomy. So again, in Chester and Ayrshire, we see a departure from orthodox principles of remoteness of damage based on autonomy concerns in this medical non-disclosure context. Now, while causation cases like Ribble and Chester demonstrate the tensions that arise when the problem of medical non-disclosure is resolved within a negligence framework, developments at the fault stage of the negligence inquiry in cases of this kind represent a more radical shift away from the negligence model, such that it's now arguably a mistake to think of the liability that arises in medical non-disclosure cases as negligence liability at all. So to make good that claim, I need to start by making the basic point that the one thing that unites the entirety of negligence law is the need for, you guessed it, negligence. While the scope of the older nominate torts, such as private nuisance and defamation, generally tracks the particular interest of the plaintiff, such as in those instances, real property and reputation, the potential scope of negligence law is limited only by the characterization of the defendant's conduct as negligent. And that simple truth about the scope of negligence explains the extraordinary flexibility of the cause of action, its ability to respond to new social problems, and an expansionist tendency encapsulated in the title of an essay by Tony Weir entitled The Staggering March of Negligence. This is a key feature of negligence, the extraordinarily broad scope of the cause of action, because it's limited only by the requirement that there be negligence. But even negligence has its limits, and changes in the law of medical non-disclosure mean that it may no longer fall within them. Now, in the UK, the relevant change occurred only in 2015 with the Supreme Court's decision in Montgomery and Lanarkshire Health Board. But that decision was foreshadowed by earlier precedents in other common law jurisdictions dating back to the seminal 1972 case of Canterbury and Spence in the United States. Now, in Montgomery, following Canterbury and other cases in other jurisdictions, the UK Supreme Court held that a doctor had a duty to warn a patient of a, quote, material risk inherent in treatment which was being proposed, and it defined a risk as material for these purposes if, in the circumstances of the particular case, either A, a reasonable person in the patient's position would be likely to attach significance to it, or B, the medical practitioner was or should have been aware that the particular patient would be likely to attach significance to it. It's a bit of a mouthful, but that's the material risk test. It's a two-part test that focuses on what a reasonable person in the patient's position would be likely to attach significance to, or any particular features of this patient that are known to the practitioner. Now, before Montgomery, the leading UK authority on the doctor's duty to warn had been Sidaway and Bethlem Royal Hospital, where a majority of the House of Lords had rejected what they called the transatlantic doctrine of informed consent and held that a test of peer professional practice, the so-called Bolam test, determined the fault issue in cases of medical non-disclosure of risk, as well as in cases of alleged medical negligence in diagnosis and treatment. So in Sidaway, the House of Lords refused to break up the doctor's duty of care into component parts and apply different tests to the different parts. They held the Bolam test applied across the board, including in relation to disclosure of risk. Now, a number of reasons were given in Montgomery for abandoning the Bolam test in the medical non-disclosure context, and those reasons centred on the need to give adequate protection to patient autonomy. And as the Supreme Court pointed out in Montgomery, the choice between a doctor-centered peer professional practice test and a patient-centered material risk test rests on whether this question of disclosure is seen as an aspect of treatment falling within clinical judgment, or instead as an entitlement of the patient to be told of risks so as to make an informed choice whether or not to run them. So the essential choice between BOLUM and a material risk test really is how you conceive of the disclosure obligation. Is that just an aspect of treatment, or is that a patient-sided entitlement to be told of risks? And in decisively opting for the latter analysis, the entitlement to be told of risks, the court was following in the footsteps not only of Commonwealth courts such as the Supreme Court of Canada in Ribble and Hughes and the High Court of Australia in Rogers and Whittaker, but also of its predecessor, the House of Lords in Chester and Afshar. So Montgomery and Chester and Afshar, although they are dealing with very different problems in this context, are very much singing from the same song sheet in terms of the focus being centrally on patient autonomy. Now, I should make it clear that I'm not necessarily opposed to the abandonment of the BOLUM test in the medical non-disclosure context. In my view, that test is rooted in considerations of judicial competence to second-guess specialist professional opinion as expressed by expert witnesses. And those institutional competence concerns arguably have less traction in non-disclosure cases than in cases concerned with diagnosis and treatment. Nevertheless, by adopting a patient-centered material risk test, rather than simply defaulting to a generic reasonable doctor test, the Supreme Court effectively abandoned negligence analysis altogether, in that for liability to arise in such a case, it no longer needs to be shown that the defendant acted unreasonably in all the circumstances of the case. Now, there's a possible rejoinder to that argument, which is to say that a reasonable doctor will disclose risks that a reasonable patient will consider to be material. But that doesn't, in my view, represent a complete answer to the problem. First of all, we can't simply assume that a reasonable doctor will be able to discern what a reasonable patient will want to know. It may be that with the benefit of hindsight, a court will be able to factor into its assessment of that question considerations of which a reasonable doctor would not have been aware at the relevant time. Furthermore, the argument that seeks to square the circle in this way fails to account for resources issues. Put simply, it may be that it's not unreasonable for a time-starved medical professional to skip over relatively minor but nevertheless material risks, particularly in the case of a non-elective procedure where it's extremely unlikely that the risk disclosure will make any difference to the patient's decision whether or not to give her consent. So I think we can identify clear blue water between a material risk test, as approved in Montgomery, and a test of what a reasonable doctor would do. If that's right, and there are circumstances in which a doctor could reasonably fail to disclose a material risk, then liability can arise under the Montgomery approach, even though the defendant's conduct cannot be characterized as negligent. The link between medical non-disclosure and negligence would then have been broken, and this area of law would be more appropriately classified as a sui generis head of liability falling somewhere between battery and negligence. Now, I should emphasize to finish that I'm only highlighting this possible rupture between the law on medical disclosure and, I'm only highlighting this possible rupture between the law on medical non-disclosure and negligence and not necessarily condemning it. On the contrary, I think that in many ways, such a development would be a positive one, which would leave the courts free to develop a set of rules governing such cases that could achieve an appropriate balance between patient autonomy and any countervailing considerations, shorn of the constraints of fitting the liability within the four corners of the negligence tort. But what I hope I have shown in that discussion is the great difficulty now of really fitting these medical non-disclosure cases into a negligence framework. And I think that raises the question of whether or not it's time to hive them off and to really try and develop a sui generis cause of action in medical non-disclosure cases rather than using negligence. So the rise of autonomy as a central value in contemporary legal societies is a relatively recent phenomenon. Even as recently as the 1970s, for example, commentators framed the issue of informed consent in the medical context as a question of dignity rather than a question of autonomy. This phenomenon, though, poses many challenging questions for private law and its future development. And in this lecture, I've focused on the interaction between autonomy and one of the most significant areas of private law, the law of negligence. The picture is a complex one, and it's not been feasible to explore every aspect of that interrelationship. But it is possible to observe in the different parts of the lecture 3 different forms of interaction. In the first part of the lecture, I highlighted the way in which autonomy considerations, broadly interpreted, are deeply embedded in core aspects of negligence doctrine. In the second part of the lecture, I argued that negligence law is capable of adapting itself so as to recognize particularized types of autonomy interference, such as loss of reproductive autonomy, as forms of damage that ground a negligence claim, while cautioning against such recognition in the case of autonomy loss per se. And in the third part of the lecture, I emphasized the tensions between orthodox negligence doctrine and a law of medical non-disclosure rooted in patient autonomy, and raised the possibility that the move to a patient-sided liability test in that context may in fact have ruptured the connection with negligence altogether. So I will stop there and thank you for listening, and we will take questions. Thank you.
Thank you, Professor Nolan. I might just start off with a few questions and try to draw some comparisons with developments in Singapore. Meanwhile, we have the Q&A box because this is in lecture mode. So if you have any questions, do type them into Q&A and not in chat. I might start off by making an observation that Montgomery was in fact adopted by the Singapore Court of Appeal in a slightly modified format in the case of Kovac, for those who tuned in the year 2017. And that seems to be quite an active year for our Court of Appeal, because that was when ACB and Thomson Medical was decided as well. I thought I might get you to comment a little bit more on how, on the one hand, the Court of Appeal in ACB had declined to recognize loss of autonomy as an actionable head of damage. And I did go back to a 2007 Modern Law Review article to have a close read of what you would classify as an actionable head of damage. But in the same breath, the court said the notion of autonomy was an important background consideration. So to me, that seems to be a rather covert way of somehow slipping in loss of autonomy as actionable damage, but in the end, using the term loss of genetic affinity as actionable damage. And the way the court sort of went around this argument was about how the ordinary human experience, I don't know if you remember, about parents and children being bound by ties of blood. And therefore, this cultural, social significance, this experience was denied to the person due to negligence, and she has lost something of profound significance and therefore suffered a wrong. So what are your views on autonomy and then loss of genetic affinity? Do you think this is an appropriate distinction or somewhat blurred?
Well, thanks, David. Well, I should first of all pay tribute to the judgment in the ACB case, which I think is sort of instantly became the leading authority on reproductive negligence in the common law world. It's an extraordinary excursus, really, of the very complex issues that are arising in these cases, and very topical issues as well. It's an interesting example of a situation where technological change is really sort of driving the law of negligence forward and posing quite difficult challenges for negligence law. So I'm really, in general terms, a great fan of the ACB case. I think it's very helpful analysis of these questions. I don't see any real conflict between the refusal to recognise loss of autonomy as a form of actionable damage and the acceptance of it as a kind of underlying value in respect of established forms of damage, or for that matter, new forms of damage such as loss of genetic affinity. In fact, that's exactly what I think the law should be doing here. It should be accepting that autonomy is important, but not necessarily elevating loss of autonomy itself into protected interest. It would be a bit like saying, we're going to recognise loss of dignity as a protected interest in negligence. I think that would just be too an open-ended an interest to protect. And I think it's much better to recognise that, again, the law of tort does try and protect dignity as a value, but through much more specifically tailored causes of action like reputation, interference with privacy, battery, and so on. I think the particular question of loss of genetic affinity, again, that raises an issue in terms of, well, how much of the harm in a case like ACB is autonomy harm, and how much of it is just other forms of harm. We do need to be careful, I think, to remember that autonomy is about choice of doing things in particular ways. And some of the harms that were identified in the ACB case, in a case of loss of genetic affinity, were perhaps not autonomy harms at all. They were just that, it might damage, for example, relationships within the family and things like that. And as one commentator pointed out, there was no loss of genetic affinity between the mother and the child. The loss of genetic affinity was between the father and the child, and yet it was the mother, as I recall, who was actually bringing the claim. So it's a very complex concept. But I think, and I think I'm not alone in thinking this, that the reception of the claim for loss of genetic affinity has generally been positive, that there is really a substantial harm here which needs to be compensated. And I think the arguments that were put forward for compensating it were very powerful. The only caveat I have with that aspect of the decision, and again, this has been, I think, a concern for other commentators, is the way in which the amount of the award was arrived at by giving a percentage of the cost of upkeep, because the court had rejected the upkeep claim or was sceptical about the upkeep claim, but nevertheless used that as a benchmark for the claim in respect of loss of genetic affinity. And I'm not so convinced that was the right way to go about assessing the damage with respect. But of course, it's very difficult to assess the damages for these kinds of things because, what is the appropriate amount to award? It's a very difficult question to answer.
Yeah, thank you for that. I might move on to another topic. You mentioned pure economic loss in the earlier part of your lecture, and I think you might be more inclined towards the assumption of responsibility principle. And I think you said a duty of care in respect of the economic interests of others should be sufficiently narrowly tailored. And in Singapore, the Court of Appeal in the case of Anwar, that's 2014, had looked at the Hadley-Burn principle and then rejected that as a sort of principle and duty of care, and in fact preferred to use it as a factor in the proximity consideration. The facts of the case was quite similar to White and Jones. And for those who are tuning in Anwar, the defendant lawyer was in a relationship, a solicitor-client relationship with the father. And the father's business was in a bit of a trouble. The sons were asked to mortgage their properties as security for their father's business. So there was no lawyer-client relationship between Anwar and the sons, but only as between the father. And ultimately, the property has to be sold, and the son said they wouldn't have signed the security documents if they had been warned of the consequences or appreciated the effect of the guarantee clauses. Our Court of Appeal referred to White and Jones and said, yes, it's something like White and Jones, but we prefer to use this spandex formulation where we look at proximity and then policy considerations. And ultimately, I think reference was made to the factor of control in Reeves and said that was important because the lawyer had control over the situation and the risk of harm. But then there was no reliance by the sons. And the assumption of responsibility was, to me, a rather distorted analysis. The court said the assumption of responsibility was to the client, to the father, but this provides the foundation for proximity between the lawyer and the sons. So it's just not very sound reasoning, but I think we still came to the same result. So what's your view on this broader expansion of proximity?
Yeah, I mean, can I just ask clarification, David? How did they say there was no reliance by the sons if the alleged negligence was supposedly a cause of their entering into these transactions?
Yeah, so there was little contact between the sons and the solicitor. And so the court said on the facts, a reliance plays a part in the analysis. It wasn't a relevant factor. And then they said assumption of responsibility because it's a legal fiction. Is that what often happens in the Hadley Byrne or the White and Jones situations, the court retrospectively imposes the assumption of responsibility in contrast to it being existing on the facts. Yes.
Yeah, well, I mean, there's lots to discuss there. I mean, the first question that I would ask is why didn't the sons get their own legal advice? What if you're going to mortgage your property, probably a good idea to get legal advice first. This is the sort of vulnerability argument that's been made in other Commonwealth jurisdictions where the courts are distinguishing vulnerable and non-vulnerable parties. Now, I don't know enough about the facts of the case to know whether they were vulnerable or not, but it's an obvious rejoinder, I think. But look, it's a complicated question. I mean, it's pretty clear. I know the Singapore courts have rejected the kind of exclusionary rule that the English courts apply in economic loss cases, and this will be an example of that. My own views on economic loss are, first of all, I do think you need to identify a right that the defendant has violated in these cases. And this was something which the Supreme Court of Canada recently held. A majority of the Supreme Court of Canada in a case called Ontario Inc. and Maple Foods, they said, you've got to identify a right that has been violated in a case of this kind. And it seems to me that the easiest way to do that is through an assumption of responsibility analysis, so that your assumption of responsibility towards me generates a right in me and a duty in you, akin to a contractual obligation, although not the same as a contractual obligation. But it's not necessarily the only way that a right can be generated in these sorts of situations, and the Canadian Supreme Court discussed some alternatives. When I get concerned is when there's no way of identifying a kind of separate right here, because I think then you face real problems in drawing lines around when you do allow recovery and when you don't. And I'm skeptical, and I've said this in print a number of occasions, so I'm not going to hide it. I'm very skeptical about the use of general tests of proximity as ways of doing that. And I'm also skeptical about multifactorial policy-based tests of the kind that are used, for example, in Australia as an alternative way of doing that. It ties back to the argument in my paper on rights, damage and loss. It's a complicated argument in some respects, but the essence of it is, look, you can't have a right not to suffer loss. There's no such thing. And so in these cases, you can either identify a right, or you can conceive of it as some kind of special liability rule, which might be the best way of understanding White and Jones. So they weren't under a duty to the beneficiaries, but they were only under a duty to the testator. But when they breached the duty to the testator, and in the very particular circumstances of that case, where that duty couldn't really be properly enforced, a liability arose to these third parties. But I think White and Jones, because of the very particular context, is a unique situation where the person to whom the obligation has been incurred is unable to properly enforce it, and then you create a liability on behalf of the third party. I don't get the impression from your summary of the Unwar case that it's quite the same as White and Jones in that sense. And so I suppose another possible solution here might be to give the claim to the contractual counterparty, the actual client of the solicitors, but then you get into problems of assessment of damages in contracts and whether they can adequately protect the interests of the third party that way. But no, I mean, my general impression, and I know that it's been said quite rightly that one has to take into account particular local circumstances and context in negligence law, and I do strongly believe that. But at a sort of more technical level, I would be concerned about recovery for economic loss in the absence of an assumption of responsibility or some other particular right that one can point to having been violated. I mean, the English courts are kind of on their own on this in a way. So who am I to say? You know, the Australian courts, the New Zealand courts, and the Canadian courts have taken a more generous view, although it's interesting to see the Supreme Court of Canada rowing back on that slightly in this most recent decision.
Now, there's a question in the Q&A box. I might get you to look at that, and I'll read that out for the purposes of recording. This is from Tim, and Tim says, "Hello, Donal. Thanks so much for a great lecture. And I entirely agree with you that we need to better distinguish damage from loss. So obviously one can suffer damage and still be better off. Example, your example of having one's leg broken and avoiding a plane flight that would have crashed. As you pointed out, the Singapore Court of Appeal and ACB equated the two, relying on Lord Hoffman's statement in Rothwell, para 44 onwards. So perhaps it would be helpful to clarify or to say, how would you characterize damage suffered by the patient in the ACB case?"
Yeah, thanks, Tim, for the question. Great question. So, I mean, it's always a problem for me, right? That my definition of, I reject the definition of damage that Lord Hoffman put forward in Rothwell, and which is extremely influential. And there's also an Australian case where the judges come up with a similar definition. My view of defining damage is actually that you can't do it, that there isn't a workable definition of damage as a general concept, and I've said that in print. I am absolutely sure that it doesn't mean being left worse off because of the number of counterexamples one can come up with. So I hold to that view. But I know that I'm in a minority on that one as far as the judiciary is concerned, but these things can change. As far as the characterization of damage in ACB is concerned, I mean, I don't think you need to look too far really there. I think you can just say, as the judge characterized it. Loss of genetic affinity was the essence of the damage in that case, and the case represents an acceptance of that new form of damage. So I have no problem with that characterization whatsoever. The difficulty I have is with these more general attempts to define damage. I think it's much more useful to try and define specific forms of damage like personal injury or property damage than to try and come up with some sort of holistic definition of damage. And in fact, this is something we were exploring in the advanced torts course that I was teaching at NUS, and it was great discussion of specific forms of damage and what they amount to. But no, I don't have any problem, Tim, with the characterization of the loss as a loss of genetic affinity. I thought it was an appropriate characterization of the damage in that case.
Thank you. There's another question in Q&A by one of my colleagues, Dan Jong Singh. I'll let you read that, and then I'll read it out loud for the recording. I wonder if we're using autonomy too loosely. Some conceptions involve the claim right aspect, interference with person, property. It means, others involve powers to waive or enforce your claim rights. Often we're concerned with infringements of these without loss or harm, in the sense that the interference with the claim right has no further negative impact on my interests. Or failure to get consent makes no difference because I would have been open to that course of action anyway. In keeping with, perhaps, your incremental and context-specific approach to autonomy, should we go further in abandoning the concept?
Wow. Okay. Great question. Thank you for that. Well, I mean, I think, what do we mean by abandoning the concept? I mean, it's a philosophical concept. We can't tell the philosophers to stop talking about it if they want to do so. And I think it's a useful concept in philosophy. I think the problem comes in translating it into law. I think it's probably one of those things that is best left as a kind of a value, which we don't need to worry about too much, at least as negligence lawyers. We can say, well, autonomy does constitute a value that underlies negligence law, but we don't actually protect it as an interest in itself. What I'm trying to do in the lecture is just try and pull some threads together. I am conscious of the fact that I'm mixing autonomy and freedom up, and that's a little bit naughty of me, I know, in philosophical terms, but it helps me to bring out some points I wanted to make about economic loss and omissions. But yes, I mean, I think in terms of negligence law, we don't really need the concept to do any work except as a value that underlies the law, and that we are better off taking this sort of incremental and context-specific approach. And in particular, I do feel that if we want to, or the question is whether we recognize something as a form of damage, we should be able to define that quite sharply, as loss of reproductive choice in a very particular sense, or something of that kind. Loss of the chance of being a father seems to me to be a sufficiently concrete form of damage to compensate in negligence, whereas I think loss of autonomy is far too nebulous.
I might close with a more general question because we've reached almost closing time. So it seems autonomy sort of rears its head at the earlier part or the first stage of a negligence claim, whether it's actionable damage or it could be recognized as that. But I would like to hear your views on how it works within a duty of care analysis, considering how the UK Supreme Court, I think, have abandoned the Caparo test. I'm not entirely clear what the test might be. I remember in Darnley, they said there's sort of no real test they could use. Singapore still sort of embraces the ANTS type test. Australia gave up and said the salient features, everything's in a basket of goods. So I just want to hear, in the UK, where do you think autonomy plays in the duty of care analysis?
Well, David, I think the kinds of cases we're probably talking about, so these sort of reproductive negligence cases, for example, there is a difficult dividing line between duty questions and damage questions. And this comes up again and again in the case law, and different people draw the line in different ways and so on. My own views on that have changed over time in some of the case law as well, I have to say. I think if we are genuinely, I think we have to bite the bullet first of all and say, in a case like ACB, are we willing to consider loss of genetic affinity as a form of damage? And I think that is a damage question, not a duty question. Once you've decided you're going to recognize it as a form of damage in a situation like that, where you have a doctor who's obviously, or an IVF clinic, which is obviously working with these people to help them with their issues with fertility and so on, it would be very strange to say that they weren't under a duty of care in that respect if you had been willing to accept that it was a form of actionable damage in the first place. But of course, someone like me would know the many duty of care in respect of this because I have nothing to do with this process. So I wouldn't expect necessarily duty to be a major issue in these sorts of cases. And the same with the imprisonment cases. If you say, well, an extended period of imprisonment counts as damage, then it would be odd to say that somebody who's been responsible foreseeably for an error that leads to a long period of imprisonment doesn't owe a duty of care. That might be more subtle, and you might have to decide what the parameters of duty were there. So.
Quick scenario. We're close to going to the pub time in Singapore, going out for drinks. I think there have been a couple of cases, Childs in Canada and Cole and South Tweed Rugby League in Australia, where it's about serving drinks after someone's drunk. So often autonomy is considered under, say, assumption of responsibility or the autonomy of an individual to make yourself silly. So imposing a duty of care kind of violates that individual autonomy to drink yourself silly. So do you think autonomy then has a place in that sort of a consideration?
Yeah, no, that's a very interesting issue. I think this whole question of liability for deliberate acts of third parties or of the plaintiffs themselves is a question that does raise issues around autonomy and self-determination and individual responsibility. The idea that you are, as it were, responsible for your own actions seems to me to be central, or an adult of sound mind is responsible for their own actions is a central consideration in that case law. You're not directly challenging their autonomy by imposing liability on a third party in respect of what they've done. But there is always this concern that if you start to chip away at individual responsibility, then the concomitant of that may be that you start chipping away at people's freedoms as well, because you're sort of infantilizing them in a sense by not taking their responsibility seriously. And that is a very controversial argument that has been made in favor of imposing full negligence liability on the mentally ill. This remarkable rule that we have that says that we don't take account of severe mental illness in deciding whether a defendant has been negligent or not. But one of the arguments that's been made in favour of that is that if we start to change the rules and lower the standard of care or recognise a defence of sort of insanity and negligence, that we may actually then end up on a slippery slope towards undermining people's rights and that there might be a connection between the two. So yes, I think if we're thinking in terms of individual responsibility and so on, then those social host cases and so on are really interesting from that perspective. I'm afraid it's a little bit early for me to go for a drink in the UK, but maybe in an hour or two.
It is 6:30 in Singapore, and I must say thank you for that fascinating lecture. We really look forward to reading the article, which I'm sure you'll flesh out a lot more of these ideas, and the practitioners and scholars amongst us would certainly be citing it in the years to come. So thank you very much. I don't think you could hear the applause, but let me do this on behalf of all the attendees. And we hope to see you in person in the years to come in Singapore.
Yeah, thank you very much for that, David. It's so sad that I wasn't able to come. I spent some time in NUS almost 20 years ago, actually, as a visitor, and it would have been great to have come back. But maybe we can do that in the future. Thank you. Thank you, everybody, for your attention as well.